Welcome. Today we're going to be talking with Judge Amado Abascal of the 365th Court. And as many of us know, this is election time in Texas. And Judge Amado Abascal is running for re-election in the three-county area of Dimmitt, Maverick, and Zavala. And it's very important during a campaign to get to know the voters, get to know the people who will make the decision of who the person that will occupy this seat for the next 4 years. And it is an honor to be here with a person who has been in this position for several years and has been doing an outstanding job. But at the same time, we're here to make sure that you, the voter, knows who he is. Judge, how are you?
Fine, Judge. Thank you. Pleasure to be here with you.
Judge, can you tell us who you are, and most importantly, tell us where you grew up, what schools you went to, where you were growing up?
Well, I'm Judge Amado Abascal, and I'm a lifelong resident of our judicial district. I grew up here in Eagle Pass on Colorado Street, right off of Quarry Street, up on the hill. Had wonderful memories of my childhood, had a great childhood, and I attended Our Lady of Refuge parochial school all the way through the 8th grade, and then proceeded to high school at Eagle Pass High School, from where I graduated in 1972. And back then, the high school was actually the one located on Del Rio Boulevard next to the Eagle Field. That was where I attended high school.
So once you graduated high school, I'm sure you had some laid out plans already. Where did you end up after that?
Well, I ended up going to St. Mary's University in San Antonio, and I did my undergraduate work there and graduated 3 years after I graduated from high school. So I graduated from college in 1975 with a major in English and political science. And immediately after I graduated from college, I started law school there at St. Mary's University School of Law and obtained my Juris Doctor degree in 1977, a little over 2 years after I started law school. So basically I went from high school to law degree in about 5 years and took the bar exam in 1977, right after, well, actually before I even graduated from law school, and got my results that same year and passed it the first time out, and been a practicing lawyer since 1977.
Well, congratulations. I think that's quite an achievement, graduating from high school in 1972. 5 years later, you're already an attorney.
That's correct.
How old were you, Judge?
I was 23 when I became a lawyer.
That is quite an accomplishment. I guess you're probably the only attorney that I know of that have become an attorney at 23.
I've known some, but I think they're highly intelligent, high IQ individuals I've come across in my career as a judge. There was some wonderful lawyers that graduate early. I was actually the youngest student in my law school class.
Well, congratulations. That is quite an achievement. So once you became an attorney, what were your jobs? Where did you go from there?
Well, I took my last law school final on a Saturday, and I started working in a law office the following Monday. 2 days later, I started working at the law offices of Ray Bettis, who, as you know, later on became a district judge in our judicial district. Judge Bettis had the law office in Crystal City, where he's from, and also one here in Eagle Pass. So I was basically running his Eagle Pass office, and we were both, working both offices, but I was primarily here, and he was primarily in Crystal City. But about a year later, he decided to close down his Eagle Pass office, and so I bought his practice here in Eagle Pass, and I went into solo practice for about a year, and then established a law partnership with Ben Martinez, who also subsequently became a district judge. And we dissolved our partnership in 1981 when our current Tri-County Judicial District was created. Ben Martinez was appointed by the governor as the district judge, and I was appointed as the district attorney in 1981. And then I served as district attorney almost till the end of 1989 after that.
So the first public service position was as a district attorney.
That's correct.
In 1989?
Well, in 81 I was appointed, and I resigned in 1989.
Okay, so 1981 to 89. How would you describe your job as a district attorney?
Well, I'm very proud of what I did as a district attorney. I feel like I had a very successful tough on crime approach as district attorney, had a very high conviction rate. In fact, one year I had a record of 200 convictions and only one acquittal. So I gave it my best. And I'm very proud of what I did as a district attorney.
Well, and if I may be so bold to ask, how big was your staff at that time?
When I first became the district attorney, I had one criminal investigator. Didn't have a secretary, so basically because what had happened was that our 3 counties were each taken out of other existing counties, and so each of those counties belonged to other jurisdictions. So when I took over as district attorney, there was no existing staff, so we started from scratch. Fortunately, the Maverick County office had a local investigator who stayed on with me, so he basically was my investigator and my secretary until we finally got a secretary, and then we went on from there. But we started with very slim pickings.
So you've seen a lot of history from the judicial perspective here in our region, and of course, right after in 1989, you went on to the next step.
Yes, in 1989, I resigned as district attorney in order to seek the bench that I now hold. That election was held in 1990. That's right, 1990, and I assumed office on January 1st of 1991. I successfully won that election.
So, Judge, as we're going into this campaign, what training have you received that makes you the best candidate, the better prepared candidate to seek this re-election?
Well, I've received over 30 years. I've been a judge for 31 years, so more than 30 years of specialized judicial training. Most lawyers get their training through state bar courses, but I get most of my training through the Texas Center for the Judiciary, which provides specialized training for judges all the way from Supreme Court judges down to county court of law judges, and it's very specialized for judges. I also belong to a couple of national organizations that provide training for me. One of them is the National Council of Juvenile and Family Court Judges, and also the Association of Family and Conciliatory Courts that provide some nationally known training for me. But I think the advantage that we also have through these training sessions is that we're meeting with other judges, not only nationally, but of course when I do my state training with all the judges from Texas that I train with. And the advantage that you have in those conferences is that you eat with them, you socialize with them, and you exchange ideas on how to better manage your courts and how to do things in a way that is more effective. So it's a learning process. So it's not just the courses that we take, but it's also the interaction with other judges and knowing how they do things. And the funny thing is, I'll come back from a conference and I'll tell my staff, okay, we're going to do this and this and that, and they say, oh, you just came back from a conference. Because you do learn these things just from interacting with other judges that have done things in different ways, and you get those ideas and you develop those things. The other training that we get is just from the experience of handling certain types of cases and the nature of the cases and the attorneys involved, and some of the attorneys that have practiced in my court are some of the best attorneys from across the country. And it's an educational process because you learn things even just being in the courtroom about the subject matter, the law that you may not have been aware of, because obviously you can't know every single law in the books. But that's something that you acquire through experience and through practice, and so that's helped a lot. And also just dealing with the litigants and what you learn about human nature and how to evaluate certain responses and activities. So all these things go into part of the extensive development and training that we receive over the years, just based on experience.
Well, if I may be also as bold to say this, is that as I talk to different attorneys and ask them who they are supporting, I always get the comment that you're a great listener, you will hear both sides, and that you always give a fair opinion. And no one leaves your court being upset, but rather they went home knowing that they were listened to and you took the side that was more justifiable.
Well, that is part of my judicial philosophy. You hear the comment about having your day in court, and I treat each case as an individual case. Every case is different, every litigant is different, and that is their day in court. Some judges have the practice, and I'm not criticizing them, it's just that it's not something that I've adopted, of maybe hearing several cases at one time, particularly in plea dockets where you have several defendants lined up and you're taking all their pleas out at the same time. And I don't engage in that practice because, again, as you say, I like to listen, I like to give specialized attention to each case. I just feel that every single case is a trial of its own and deserves its own attention. And I believe that the only way that you're going to lend confidence in the judicial system to the litigants and the parties involved is by giving them their day in court. And sometimes things do tend to go longer than necessary. But I feel that at least by not cutting people off unnecessarily, that they feel that they were at least given the opportunity to present their case. And I think that goes a long way in establishing trust and confidence in our judicial system, that when they leave there, that even though the outcome may not have been in their favor, that at least they feel or felt that they were heard and they had a chance to present their case. I think the opposite would be true if they were cut off, and the result may have been the same, but their outlook on it may not have been the same because they may have felt that they lost the case merely because they weren't given a chance to completely give their side of the case.
Thank you. Thank you for elaborating on that. That's really, one of the key things that I hear out there. Moving along, I have a question. In your court, there's always certain cases that can be called complex. What kind of experience have you had with what are called the complex cases?
Well, again, because of the number of years that I've been on the bench, I've had an opportunity to hear many high-profile cases, one of which that was even written up in the Wall Street Journal because of the nature of the case. It involved a major corporation, and some of the lawyers were even from New York. I mean, it's just, I've handled some very big cases. The complex cases that we're talking about would be, for example, products liability, and that would range from design defects, manufacturing defects, or even marketing defects, medical malpractice, oil and gas, fraud cases. I've handled mass tort cases, class action cases. I've handled some capital murder trials. Relatively speaking, very few judges, district judges in the state, have ever heard a single capital murder trial. I've done two in which the death penalty was a potential punishment. And those are very specialized cases that like I say, not very many judges have had that opportunity. But so there are some very complex cases out there. I've had cases where I had 2,500 plaintiffs because there was just a lawsuit that was initially filed in one of my counties, and then litigants from all over the world, as far away as Australia even, joined the lawsuit because it was the same subject matter. And so for the judicial economy purposes, they were tried they weren't all tried, but they were all filed in my case, and then we kind of worked some of them out, and the rest were able to be resolved because of the outcome that we had on those other cases. I had one case where I had 29 oil companies in the lawsuit. I walked into the courtroom, and my courtroom was full, and I'd say, what are we doing, selecting the jury? Because there were so many people there. And they said, no, those are all lawyers. Those are complex cases, and it requires someone that knows how to manage those type of cases and to handle that type of docket.
Well, thank you. I think that really opened up my eyes too, because those are very complex cases. These are hard times throughout. COVID has had an impact on businesses, on government, on all phases of life. How has it affected your court?
It has affected it considerably, but not to the extent that we aren't able to still function. Obviously, our purpose is to try to do justice for the citizens of the state. Initially in 2020, when COVID first hit around March of 2020, when it really started impacting us, we did receive a mandate where we were basically shut down except for emergency matters. And I remember the date very clearly because it was March 20th, which was my birthday, which was the day that I told my staff, okay, we have to shut it down. And so we went home and did remote work for about 2 months, with the exception of my court reporter and I, because we were still required to conduct emergency hearings, even though we were shut down. If there were people in jail that needed to have an emergency hearing or whatever, we would still have to preside over those matters. So the way it would work is that remotely my staff would prepare my docket sheets, send them to our printer at the office. I'd get to the courthouse, get the docket sheet from my printer, and go upstairs and hear that case. So for about 2 months, my office was working remotely. But then around the first part of June, I said, folks, it's time to come back. And we came back because by that time, the Supreme Court had already passed one of their emergency COVID orders that gave us some guidance as to how we could go ahead and start proceeding again with in-person proceedings. So it impacted us to the extent that initially we had to do things remotely, but then after that, we were able to kind of come back and get to more of a normal function, although we still have to proceed with certain minimum health protocols that we still, to this day, are still implementing.
And that is such a big impact on our community, on our economy. I think that when we think of COVID, it does not just affect a certain group of people. It has affected all of us, and in many ways. It can affect us on employment. It can affect us on illnesses. It can affect us on our revenues coming into the house, or being able to pay the rent. So I think you've touched on a subject that the court has to continue. The world has to continue to move. And same thing happens in our court system. When you take a look at COVID, have you had any jury trials at this point?
We have. Basically, when the Supreme Court issued the emergency order that took effect June 1st of 2020, that allowed us to then continue to proceed with in-person proceedings. Before we were able to do that, though, I, as the local administrative judge, was charged with responsibility of preparing the COVID-19 operating plan for in-person proceedings. I literally spent weeks in the preparation of that plan. That plan had to be approved by my local administrative judge as well as the Office of Court Administration before we were allowed to conduct in-person proceedings, even though that would have taken effect June the 1st. What went into preparing that plan was to analyzing all of the emergency Supreme Court emergency COVID orders that existed up to that time, which I think at that time was like the 32nd, 33rd emergency order. So I read all of those orders to make sure that I complied with everything that the Supreme Court, as well as the Court of Criminal Appeals, was requiring us to do, as well as the Office of Court Administration, which also issued its guidelines that we had to follow. So I had to implement all of those requirements into our operating plan. I also had, as part of the plan, the requirement to meet with each of the local health authorities in the 3 counties and to present my plan to them and get their approval that I had done everything, included everything in my proposed plan that would be reasonably safe for any participants that came to the courthouse. So that had to be done. I consulted as part of the requirement with all of the judges in my counties, all the way, of course, from district judge, which would have been Judge Flores, and the county judges in each county, as well as the JPs, because they were going to be subject to whatever operating plan I was going to present. So that required that consultation. That's why it took several weeks to actually finalize the plan. I think my original plan is almost 6 pages long. And like I say, that took effect June the 1st. The Supreme Court then subsequently entered another emergency court order, which allowed us to then start conducting the jury trials. And that required that I draft the addendum to our operating plan for jury proceedings. So again, we start all over again and had to develop another plan, and I think that one is almost 6 pages long. That is a very detailed plan that takes into account the fact that we're going to have jurors coming to the courthouse, not just the litigants. My initial operating plan, among some of the provisions that it included, required us to basically screen everyone that comes into the courthouse. We take their temperatures. We screen for whether they've been in close contact with anyone who has COVID, whether they've been tested positive with COVID, or whether they have any symptoms that may be COVID-like. If that's the case, as part of the operating plan, they're not allowed to come into the courthouse. So those are part of the things. We also require that they, of course, wear their masks. We require the social distancing. We have sanitation stations throughout the building and several in the courtroom itself. We also have a minimum capacity of 2 persons in the elevator, 2 persons in the bathrooms. All these things that we've imposed as part of protecting the public when they come to the courthouse. We also have the requirement to sanitize and clean the courtroom constantly. If a person sits on a chair, when they get up, we spray the chair down and sanitize it before another person is allowed to sit on the chair. So we had all those requirements as part of our original in-person plan. With respect to our jury trial proceedings, in addition to the operating plan that we have for our regular in-person proceedings, we had to implement some additional requirements in order to meet the minimum health protocols for the jurors that came to our courthouse. So one of the things that we've done is that with the summons, the jury summons that we send out in the mail, we've included some additional instructions to the jury. One of them is just basically explaining to them what they can expect when they come to the courthouse, and what is required to them. Again, is just letting them know about the social distancing, the wearing of the mask, and the sanitation requirements. Also, we have a questionnaire, and the reason for the questionnaire is because we want jurors to notify the court before they even come to the courthouse whether they've been exposed to anyone who had COVID, whether they have any COVID-like symptoms, or whether they themselves may have had COVID. And normally when jurors come to court, they present their excuses as to why they don't want to serve to the judge at the time they come to court, but because of COVID, we've adopted this plan that they are asked to call us in advance and not even show up to the courthouse, because in the event that the court should excuse them from appearing because of any of those health concerns. So we also have that. And that, again, has been very helpful, because we do get a lot of jurors that will call in, and we screen them over the phone, and then many of them we tell them, it's better that we defer you. The other thing that we've included as part of our operating plan is that we have, as you know, statutory excuses and exemptions that jurors may claim. Some have to do with disqualifications, others have to do with just exemptions that they can claim. But in addition to that, we've given them, under our jury operating plan, the option that if they have a genuine COVID concern, that the court will nonetheless still excuse them, even though it's not a statutory requirement. We don't want anyone to come to the courthouse and serve on a jury if they are generally concerned about being in public spaces. So it's not like anyone that is concerned about COVID is being forced to come to the courthouse and serve as a juror. We are taking that into account, and we're giving them that courtesy of not requiring them to come under the circumstances, because some people do have a legitimate concern. I'll be honest with you, when we started our jury trials, I had one lady call me up and ask for an excuse, and at the end, after I excused her, she said, "Judge, I really needed to be excused, but I almost wish I didn't have to be excused, because I'm really ready to get out there and live my life and do something again." And I think that's where a lot of our citizens are, and I think that's why you see much more activity in public places now, because people understand that we have COVID, but we are learning to live with it and take the necessary precautions, but we need to go ahead and still function as a society. And I think that's what we're doing with our operating plan, in order that, as I said, following the Supreme Court, Court of Criminal Appeals, and the Office of Court Administration guidance, that we still provide justice to our citizens, that we are giving them the accessibility to our courts and trying to conduct our business. So that's all part of our jury plan.
Well, and I think to take it a little bit further down the road here, we go to the grocery store, we go to the gas station, we go to many different places that are public, and some are strict, some are not, and I think a lot of it also has to do with the personal responsibility. When people go into a certain area, watch your distance, wear the mask, do the sanitizing. If you choose to not do that, well, that's a different story. But it's pretty much up to each person. When you take a look at the other option of possible remote hearings, are you doing any of that currently?
We're doing a little bit of it. I mean, even before COVID, in some instances, rather than have someone drive in from out of town, if it was just a quick announcement, we might conduct a hearing over the phone. But because of COVID now, that has opened up a different avenue. I'm doing a little bit more of it, but only to the extent that because of COVID, someone may have expressed to us that they were exposed, or that they're having symptoms, or they may have tested positive sometimes back and they just don't feel comfortable coming to the courthouse. So depending on the nature of the hearing, if it's just a simple announcement or just a short argument to the court that's not an evidentiary type hearing, then in some instances we are allowing them to participate remotely, and only for the purpose of not having to postpone or delay the resolution of that matter. And because those can be easily done remotely, as we did other things on the phone even before COVID. But only those simple things are we doing remotely. But as I say, most of the more complicated matters and the evidentiary matters where you want to really have an opportunity to see the witnesses and to be able to weigh their testimony, we're in those instances we're mainly requiring them. Now that we have this operating plan in place, requiring those to be in person.
It's a tough time to be out there, and every business, every court, every governmental entity has set certain procedures that we need to adhere to. Working remotely can be a challenge, and I can tell you that from my own personal experience. When COVID was really out there and nobody knew what was going on, we could do a lot of things remotely. At this point in our type of work, we're going live and we're going in person, and we're just following those procedures like you have set up in the court. Judge, in my business, I serve in some regional and some state-wide groups, committees, and boards that we have gradually gotten away from the virtual or the remote because we see a lot of challenges in trying to get certain things done. In the court system, tell me about the challenges that you have using, let's say, Zoom, for example.
Well, the reason we started even using Zoom when COVID started was because at the time we just hadn't prepared to how we were going to handle our system in an intelligent way until we knew more about COVID. And so Zoom was allowed by the Supreme Court and the Court of Criminal Appeals as an emergency measure in order for the courts, as I said, so that justice could still be done for the citizens of the state. But it's, as of now, I don't expect that it's going to be a long-term approach. In fact, the current Supreme Court order, which is a 47th emergency COVID-19 order, is set to expire on April 1st, subject to it being extended by subsequent order. But this is just a temporary measure to get things rolling again. But now that the court has allowed us to do the in-person hearings, we now can weigh the difference of having in-person as opposed to the remote. And when we were doing exclusively remote, except for those emergency in-person hearings, We did face the same challenges that you probably did, but in our case, probably even more so because of the fact that we have to make a record of these proceedings. Some of the challenges is that it's not as efficient as having the persons in the courtroom. For one thing, you've got to get everybody on the line, every participant on the line, and hope that they're there and they're connected. The other thing is that once you start the hearing, some Zoom systems will only allow one speaker at a time. So while someone is speaking, if another party makes an objection, that objection is not heard. And so you don't even get to hear that objection. And then other systems will allow everyone to speak at once. But again, when you consider how many participants may be in a single hearing, you're having to deal with all the background noise in each one of those attendees' systems. So you have the noise issues to begin with. But what's been the main problem is just everyone talking over each other. The court reporter's responsibility, because we are a court of record, is to make a proper record of the proceedings. But when everyone is talking over each other, she doesn't even know who said what, and therefore we can't even have the assurance that a proper record is being made, much less taking down everything that's being said. When you're in the courtroom, when people start talking over each other, the judge can raise his hand, get their attention, the bailiff can calm it down. You can get control of the situation. In Zoom, it's a different ball game, and everybody, because they don't have the presence in the courtroom and the decorum that you have in the courtroom, they become a little more relaxed in how they do things, and they just start going. So we do have that problem. Because I do have a court reporter on my staff, and I'm aware of the difficulties that she's had because we've had all these trials, and she's been preparing records, and we've had other hearings that we've done by Zoom. I know the difficulties that she's had in preparing the record because of the fact that people were talking over each other. So there is that problem. But then there's other practical problems. One of the first jury trials that was conducted remotely, one of the jurors just got up in the middle of the trial and went to the restroom. How do you control that? I mean, we've had other problems where I had a San Antonio lawyer told me that he had a few weeks ago been involved in a remote jury trial, and the judge kept asking the juror to please sit up because the juror was laying in bed through the whole trial. These are the problems that you have. I am a lifelong jurist. I've been doing this for over 30 years. I have a certain perception of how the courtroom should be and how the judicial decorum should be. And frankly, that's just not the way that I think that our courtrooms and our trials should be run. I think that we need to have certain dignified process. We have to have proper decorum. And Zoom sometimes doesn't allow that. So we do have those issues. So there's many reasons why. We also, if you've ever watched a television program where they have a panel of participants, you'll hear a lot of times one of the speakers say, "Oh, we've lost so and so," or "We lost the audio so." That happens to us in Zoom. So we discover some point down in the proceeding that so and so is no longer on the line. So we need to kind of, first of all, get them back on the line, then try to figure out at what point they were cut off. And then we got to go back and repeat all of that discussion or testimony. So it's not truly an efficient way to conduct the court. When it was absolutely necessary because we didn't have a grasp on COVID and we didn't have these protocols, I could understand. And while we're still being allowed in certain circumstances to conduct our remote hearings, I just don't think it's an ideal way of doing it. If you have a safe way of still proceeding with the in-person hearings. Additionally, a lot of times just having the parties there in person can get some resolution to certain things because you get the parties together. They're there. They can exchange documents. They can have discussions. If you have a client that needs to confer with his attorney, if you're in a Zoom hearing, you have to stop the hearing, put them in a different room in the Zoom room, and so they can have their private discussion, and then you can resume. Whereas if you were in a normal court proceeding, the attorney could just lean over and the client could ask the question. So anyone that says that it's more efficient, I'm telling you from my experience, I've been dealing with COVID proceedings for over 2 years. That has not been my experience. In fact, it's just the opposite. I think it's more efficient and more productive to have the parties there in person, even under these difficult circumstances, because it's just a better way of doing things. And again, when everyone is able to see the documents and exchange them, it just makes things go a lot quicker.
Well, and I can tell you from personal experience that the acoustics of a room makes a big difference. And I was in a Zoom meeting. Someone was talking after I said certain things. I thought he was arguing with my point, and I started arguing with but I was really I couldn't hear clearly what it was that the person was saying. You know, there's a lot of issues with the sound also. It's not just the video, it's not just the sound. There's a lot of, you know, you have to have a professional setting, and for a court system to operate, it's probably a very weak way to get it done. There's a lot of things that have to be fixed, but then you have too many. It would not be cost effective.
Yeah. And another example is, again, our system of justice should be such that we have a just result. If you have proceedings, evidentiary proceedings, remotely, and this is just something that comes across my mind, what assurance do we have that there isn't someone coaching the witness across from the camera? What assurance do we have that is not really a just result that's going to be obtained, or that someone may be texting them the answers? I'm not saying that I know for a fact that it's happened, but that possibility does occur to me. And as a judge, you want to make sure that you have a just outcome. And the only way that you can do that is to have a process in which the judge can control the situation. Again, in a remote jury trial, I personally, my personal opinion is that I don't think it's a good idea, because again, you don't know if someone in the room is hearing, or in the house where a jury may be, is listening to the jury deliberations, which again would be a violation of the rules, or they may be coaching a juror during deliberations, which is supposed to be confidential, that may result in an unjust outcome. And that's why I say we have to protect our system of justice and the way our courts were designed to run in order to make sure that everyone is afforded a fair system. And if there was no other way to do it other than remotely, then we would have to live with that. But because of the protocols that we've established, the protections that we've put into place, I think we're reasonably safe to conduct these proceedings in a more dignified and a more just outcome manner than we would if we just unnecessarily started having these remote hearings that could result with a bad outcome.
Thank you, Judge. I guess a question that I have, and you mentioned earlier, being the administrative judge, can you tell the public, the citizens of these 3 counties, what are your responsibilities as the administrative judge?
Well, each county has a local administrative judge, and that is basically the one that administers the courts in that particular county. Basically, the court makes sure that the courts are functioning in an orderly fashion. If there's a conflict in scheduling calendars, the administrative judge will address those. The administrative judge also has other functions. For example, as the administrative judge, I appoint the members of the appraisal district boards in each of the 3 counties. I also appoint the officers of those boards. So there's many other functions that the local administrative judge has, in addition to just presiding over their individual court.
Thank you. I think that's an important part that a lot of people don't realize, the extra things that an administrative judge has to do.
Well, I don't think a lot of people realize the extra things that district judges have to do, because we have so many other administrative responsibilities other than just presiding in court. It was funny because there was one day that I had finished court and I was still on the bench, and an out-of-town attorney came up and said, "Judge, you have court tomorrow." And he said, and I told him no. And he said, "Oh, that must be nice to have the day off." And I was thinking to myself, you have no clue, because we have basically 14 other administrative responsibilities in addition to being trial judges. As you know, we supervise the probation department, juvenile probation. We supervise commissioners' courts. We're on the purchasing board, I mean the juvenile board. There's so many other responsibilities. We appoint the county auditor, so we supervise that auditor. We appoint the district clerk in the event of a vacancy. There's so many other functions that we have as district judges. And obviously there's issues with jails and stuff that sometimes the sheriffs ask for our guidance. So there's many other things that we're involved in. So there's a lot of administrative responsibilities. We also have a department to run. We're department heads. So we have to manage personnel. We have to manage a budget. So there's many things involved.
Thank you, Judge. I'm going to go back a little bit to the in-person hearings. Will you continue to conduct in-person hearings if circumstances allow it in the court to do so in a reasonable manner?
Well, in view of the fact that the Supreme Court has authorized us to do it, yes, I will, as long as we can do it in a reasonably safe manner. In addition to everything that I've already explained that we do also provide masks for anybody who doesn't have a mask. We provide face shields for anyone that needs to remove their mask for any period of time. Let's say a witness can't testify to the mask, having difficulty, we'll provide a face shield. We also provide latex gloves. If anyone needs to handle an exhibit, in order to make them feel more comfortable, we have latex gloves available. And we require that if they use the gloves, that they remove the gloves before they handle another exhibit so we don't cross-contaminate. So there's a lot of things that we're doing. And you mentioned about how the general public has now started to go out and live a near normal life in spite of COVID by going to public places. And I can say, just based on the protocol that we have established, while there is no guarantee that someone may not contract COVID at a courthouse like they could anywhere else in a public place, I think that the measures that we're taking are probably exceeding many measures that most public facilities provide because of the protocol that we do, because we are requiring the wearing of masks. We are screening people when they come into our courthouse. And many things that we're doing that in many other venues are not being done. So I think we're making it reasonably safe. And as far as I know, I don't believe anyone has contracted COVID as a result of being in the courthouse. There have been individuals that have come into the courthouse that we found out later on after they tested that they were COVID positive, but I have not known of any case because of the measures that we're taking, because we're all still wearing our masks and socially distancing. Now, even when we don't have court, my staff and I wear the mask all day long. Even though may they be there for 8 hours, we're wearing the mask all day long. So we are doing our part to protect everyone that comes into the building. Our courthouse doors are still locked, and the reason we do that is so that no one enters the building without us having the opportunity to screen them. So that way, when we open the door, if they're not wearing a mask, we tell them they have to wear the mask, as opposed to them coming into the building and stepping into the office and not wearing the mask. So we are doing everything that is reasonably possible for us to be able to function and to provide the service that we're there to provide, which is to run the court.
Why is that important?
It's important because the judicial branch of government is 1/3 of our system of government. And the reason that we have government, as you all know, is so that we can have a civil society. And if you don't maintain this co-equal branch of government in a functioning manner, then we are going to lose that as a society. So I think it's very important that we have a functioning court system under the circumstances. It's limited in some respects to how we do things. But we've got to make it as functional as possible so that we can move on with the business of the court. The court system is the way that people resolve their disputes, and if you don't have that opportunity, then chaos would follow, and that's why I think it's very important that we continue to have our courts functioning to the best possible way.
Any closing words here?
So I want to, first of all, thank everyone. I am honored to be in elected office for as long as I have. I've been honored to serve as your district attorney and as your district judge for almost 8 terms now. So I'm very, very fortunate to have had that respect and trust in my community to allow me to serve in this capacity. I believe that we have to have an effective judicial system. We have to understand that what judges do is to afford due process to everyone. And that includes providing a speedy trial and providing the right to confrontation in criminal cases. Those are constitutional rights that are in our Constitution. And we must be able to have the court function as effectively as possible, efficiently as possible, in order to ensure that everyone has their constitutional rights protected. This is the reason that we started having our jury trials, because persons still have to have some resolution of their disputes without unnecessary delay. We have had to make certain accommodations. Because of the social distancing, we are now required to have jury selection in a larger venue, and I'm grateful to the City of Eagle Pass for allowing us to use the ICT Center for jury selection so that we can have a larger group of individuals that then can socially distance, and also to the County of Dimmitt for allowing us to use their convention and rodeo arena facility, and also to the County of Zavala for allowing us to use the Nutrition Center where we've been conducting jury selection. We've had jury trials in all 3 counties since COVID, and so these governmental entities have made it possible for us to do that. So the reason that is important also is particularly in criminal cases, because in criminal cases, as you know, Constitution, the defendant has a right to confrontation, and so they have the right to require that their accusers be brought and before them. And if we don't have in-person trials, the defendant could object to not having that right afforded to them, and therefore we could not proceed unless we had an in-person trial, which means that these defendants' trials are delayed, and some of them have been in custody because they have not bonded out. And so this is why it's important, and I feel that it's my job to make sure that we run the court as effectively as possible, but taking into account all the necessary requirements to protect the participants that come to court. But it's still important. So again, thank you for your support for all of these years that you've allowed me to be your public servant, and I just want to take this opportunity to humbly ask for your support and your vote and your continued trust in allowing me to serve in this capacity. The district court is a very high office, and it has a lot of responsibility. It's a very demanding job, and I think it requires someone that has the experience and the training to do the best possible service for our community. I'm reminded of a 1993 movie, The Philadelphia, where there was an attorney that was given a very important case in a big law firm, and it was probably the biggest case in that law firm. But then he was terminated when the law firm discovered that he had contracted AIDS, and there was a wrongful termination suit filed by the attorney. And the question that the jury was going to decide was he terminated because he contracted AIDS, or because, as the law firm was arguing, that he was a mediocre lawyer. Well, during the deliberations in that movie, the jury foreman asked the jurors, in trying to decide, okay, the answer to that question was, if you had a combat mission and you had a $350 million plane, who were you going to put behind that plane? Were you going to put a mediocre pilot, or were you going to put your best pilot, your top gun, your most skilled pilot? And the answer is obvious. And I think that is what I'm kind of hoping that our electorate will see. And I know that our electorate is an intelligent group of individuals, that a district court requires that you have your best qualified, your best trained, your best capable judge there. And I firmly believe that of the two candidates in this race, that I am that person, that I've proven my ability to handle a heavy court docket and handle complex cases, and also to demonstrate proper judicial temperament and to decide very difficult matters in a fair and honest way, based on the facts and the evidence as presented. And that I have run my court in an independent fashion and not controlled by any special interests. So this is what I bring to the table in this race, and I hope that the voters in Dimmitt, Maverick, and Zavala County will see fit to lend me their support and their vote one more time for a successful outcome in this race.
Thank you, Judge.
Thank you.
Ladies and gentlemen, this has been the Honorable Amado Abascal, who is the District Judge of the 365th Court for Dimmitt, Maverick, and Zavala County. We ask for your vote.